Chapter 7. Seamen. Shipping contract. Shipping contract. How formed. How signed. Erasures and interlineations. Unusual stipulations. By the law of the United States, in all foreign voyages, and in all coasting voyages to other than an adjoining state, there must be an agreement in writing, or in print, with every seaman on board the ship, excepting only apprentices and servants of the master or owner, declaring the voyage, and term or terms of time, for which such seaman is hired. Act 1790, Chapter 56, Section 1. This contract is called the Shipping Articles, and all the crew, including the master and officers, usually sign the same paper, it not being requisite that there should be a separate paper for each man. If there is not such a contract signed, each seaman could, by the old law, recover the highest rate of wages that had been given on similar voyages at the port where he shipped, within 3 months next before the time of shipment. Act 1790, Chapter 56, Section 1. By the law of 1840, he may, in such case, leave the vessel at any time, and demand the highest rate of wages given to any seaman during the voyage, or the rate agreed upon at the time of his shipment. Act 1790, Chapter 23, Section 10. A seaman not signing the articles is not bound by any of the regulations, nor subject to the penalties of the statutes. Act 1790, Chapter 56, Section 1. But he is, notwithstanding, bound by the rules and liable to the forfeitures imposed by the general maritime law. 1 Pet Ad 212. These shipping articles are legal evidence and bind all parties whose names are annexed to them, both as to wages, the nature and length of the voyage, and the duties to be performed. 3 Mason 161, Act 1840, Chapter 23, Section 3. Accordingly, seamen have certain rights secured to them with reference to these papers. In the first place, the master must obtain a copy of the articles, certified to by the collector of the port from which the vessel sails, to take with him upon the voyage. This must be a fair and true copy, without erasures or interlineations. If there are any such erasures or interlineations, they will be presumed to be fraudulent, and will be set aside, unless they are satisfactorily explained in a manner consistent with innocent purposes, and with the provisions of laws which guard the rights of mariners. These articles must be produced by the master before any consul or commercial agent to whom a seaman may have submitted a complaint. Act 1840, Chapter 23, Section 2, 19. Every unusual clause introduced into the shipping articles, or anything which tends to deprive a seaman of what he would be entitled to by the general law, will be suspiciously regarded by the courts, and if there is reason to suppose that any advantage has been taken of him, or if the contract bears unequally upon him, it will be set aside. In order to sustain such a clause, the master or owner must show 2 things. First, that the seaman's attention was directed toward it, and its operation and effect explained to him. And secondly, that he received some additional compensation or privilege in consideration of the clause. Unless the court is satisfied upon these 2 points, an unusual stipulation unfavorable to a seaman will be set aside. 2 Sumner 443, 2 Mason 541. For instance, seamen are entitled to have a medicine chest on board, and in certain cases to be cured at the ship's expense, and the court set aside a clause in the shipping articles in which it was stipulated that the seaman should bear all the expense, even though there was no medicine chest on board. 2 Mason 541. Another clause was set aside, in which the voyage was described as from Baltimore to St. Domingo and elsewhere, on the ground that seamen are entitled to have their voyage accurately described. 1 Hall's Law Journal, 207. 2 Gall, 477, 526. 2 Dodds, 504. Gilpin, 219. Some clauses which are not such as to be set aside will yet be construed in favor of seamen, if their interpretation is at all doubtful. 1 Pet Ad 186, 215. A clause providing that no wages should be paid if the vessel should be taken or lost, or detained more than 30 days, was set aside, seamen being entitled to wages up to the last port of delivery. 2 Sumner 443. If the amount of wages merely be omitted in the articles, there seems to be some doubt as to the introduction of other evidence to show the rate agreed upon, and as to the seamen's being entitled by statute to the highest rate of wages current. Gilpin 452, Abbott on Shipping 434, note. Act 1840, Chapter 23, Section 10. If a seaman ships for a general coasting and trading voyage to different ports in the United States, and the articles provide for no time or place at which the voyage shall end, the seaman may leave at any time, provided he does not do so under circumstances peculiarly inconvenient to the other party. Where 437. If, however, the voyage is accurately described and the wages specified, the seaman cannot be admitted to show was different from that contained in the articles. Gilpin 305. It is no violation of the contract if the vessel departs from the voyage described by accident, necessity, or superior force. 2 Hag 243. Seaman and shipping contract in England. The shipping contract required to be made by the law of England is similar to the one prescribed by the law of the United States. The form of it is given by the Act 5 and 6, William IV, Chapter 19. See the schedule to the Act. This agreement, called the Ship's Articles, must specify what monthly or other wages each seaman is to be paid, the capacity in which he is to act, and the nature of the voyage in which the ship is intended to be employed, so that the seaman may have some means of judging of the probable period for which he is likely to be engaged. The agreement must also contain the day of the month and year in which it is made, must be signed by the master in the first instance, and by the seamen respectively, at the port or place where such seamen shall be respectively shipped. And the master must cause the same to be, by or in the presence of the party who is to attest their respective signatures thereto, truly and distinctly read over to every such seaman before he is required to sign, in order that he may be able to understand the purport and meaning of the engagement he enters into, and the terms to which he is bound. 5 and 6 William IV, Chapter 19, Section 2. Any agreement contrary to or inconsistent with the provisions of the last-mentioned statute and with the right to wages given to a seaman by the maritime law, in case of freight earned by ships subsequently lost, is declared not to be binding upon him. Section 5. By signing the agreement, a seaman does not forfeit his lien upon the ship, nor is he deprived of his remedy for the recovery of wages against the ship, the master, or the owners. Section 5. The master and owners are bound, on reporting a ship's arrival from parts beyond the seas, at her port of destination in the United Kingdom, to deposit a true copy of this agreement with the collector or controller of the customs there, that the means of ascertaining the terms and conditions of it may be accessible to all who are interested in it. The masters of ships employed in the fisheries on the British coasts, or trading from port to port of the United Kingdom, or making regular voyages to the Channel Islands, or to ports on the continent of Europe, between the river Elbe, inclusive, and Brest, must twice in every year deposit copies of all such agreements entered into by them during the preceding 6 months. Section 3. If any master carry out to sea a seaman without having first entered into such an agreement with him, he forfeits £10, in respect of every seaman so carried out. If he neglect to cause the agreement to be read over to the seaman, he forfeits £5. And if he neglect to deposit a true copy of it with the collector or controller of the customs, £50. Section 5. The master must deposit the ship's articles on his arrival at any foreign port, with the British consul, or vice-consul, for preservation during the ship's stay there. Penalty for omission, £25. Section 48. No seaman shall be shipped by the master at any such foreign port, except with the privity of such consul or vice-consul, to be endorsed upon the agreement, under a penalty of £25. Section 49. The master must produce the muster roll of the ship and the agreement with the crew to the captain, commander, or other commissioned officer of any of Her Majesty's ships requiring a production and sight thereof, under the penalty of £25. Section 50. The master must also, upon demand, produce such muster roll and agreement to the register and officers of customs in the British possessions abroad, under the penalty of £50. Section 51. When a written contract is made, it becomes the only evidence between the parties, and a mariner cannot recover anything agreed to be given in reward for his service, which is not specified in the articles. Abbott on Shipping, 6th edition, 550. To Boss and Pull, 116. To Rob ad Rep, 241.